2027 back in session.
Thanks, everyone. Please be seated. Ms. Stein, did you get a chance to look at everything?
I did, Your Honor, and obviously we could move forward. I still think that in the future, I would ask that they, one, file it correctly, and two, serve us with a copy of it, because, again, we didn't have anything, and we still haven't technically been served with anything, but we're fine to move forward.
Yeah.
I do have another housekeeping issue I do want to address, though, and it's also very serious to us. Mr. Genis, who is clearly speaking here for the three plaintiffs, is, as the court is aware and is filed in our papers, is an attorney. He's suspended in the state of California, not licensed in Nevada. It appears he's continuing to practice law by representing, but there's more troubling is that on Twitter today, they posted, and if I may approach, Your Honor?
I haven't seen what counsel's trying to show the court.
I have a copy.
Make sure that Mr. Genis, is this two copies?
Yeah, one was for him, I apologize.
Our marshal's filling in today, so.
Yeah, sorry about that.
Thank you.
So, Your Honor, exclusive DUI is Mr. Genis. And what's most troubling, if you go to page 2, they actually post a picture that was supposed to be of our law offices. Unfortunately, what they did was post a picture of Mr. Flangus' cousin Leo's office, as you're aware. And
I drive by it every morning on the way to work.
but if you continue to go through this thread, he talks about not only representing and how he's going to represent all these people. I'm going to get into that in a moment. There's a post, if you go through, and it's actually referencing Saul, S-A-U-L, and it says, you know, it's better off Saul, I think is the show, I'm not positive, and it says, I'm way better than Saul, but if you look, it's a guy behind going to hit the attorney. We take that very seriously. We're very concerned. We let Mr. Leo Flangus' office be aware of it, but we have concerns on the actions of Mr. Genis, who's also been part of his probation in California was because of his actions in a courtroom against prosecutors in a case 4 different times where he was caught on video taking certain actions. So we would just ask the court to take notice of that for the future, and hopefully that we can act professionally as we go forward.
You know, there is a First Amendment. You can violate it. But in cases in this courtroom, even in very high conflict cases, I do not allow anybody to act out in the courtroom. And if you do, there are consequences, right? So,
Thank you.
Mr. Genis, you
Yes,
realize you have the right to represent yourself. You do not have the right to represent the other plaintiffs.
Yes, Your Honor, what counsel has just said to the court, I'd like to address because of the inaccuracy of her comments and the gravity of the
There will be
comments.
no personal attacks at any time in this courtroom. We will be escorted out.
I am not going to attack anybody, but I'd like to address the attacks that have been levied against me.
You can respond.
Thank you. Okay, first of all, I'm currently on a 24-month suspension, which is what's called a referral case, based upon.
I don't really care. You have the right to represent yourself.
Yes, I do. Okay, so let's just say that I categorically deny both conjunctively and disjunctively every spurious accusation that Ms. Stein has leveled against me on the record, and I find that that is inappropriate, unprofessional, and violates the Nevada rules of professional conduct.
I don't want your
She's trying to
opinions,
intimidate me.
and
It's
I
not
don't
gonna
want
work.
No, I'm not gonna allow any
Thank you.
name-calling on either side.
Enough said on
So,
that. Now, can I
stop.
address these documents that counsel provided to you?
You may.
Okay, so I appreciate what you said about the First Amendment and my right to represent myself. I do want to say that I do not represent anybody but myself. We have 2 other in pro per plaintiffs. Mr. Vick is present physically and Mr. Muntz is present virtually. And we have worked together and we have written these documents together. And yes, I do have a legal education, and yes, I do have a lot of experience in litigation, albeit not in Nevada, and albeit not in civil. However, you can't remove that knowledge and that experience from my person when I'm representing myself here in pro per. I know you appreciate this, but apparently Ms. Stein
No,
is
no
not appreciating
personal
it.
attacks.
Okay, I'm not
If you do it
attacking you.
again, I'm gonna
Okay,
kick you
all
out
right.
of this
Well,
room.
I've said enough on that, but with respect to these documents that she's just provided to you, if you're gonna take the time to look at them, and I don't think that you need to, you'll notice that most, if not all, of what she's posted, I didn't post it. Somebody else did. And the first page is a picture of a website that is not currently on. In order to get this picture, she would have had to go to the Wayback Machine. And the reason I say that is because in order to be in full compliance with the State Bar in California, immediately prior to August 28th, the beginning date at midnight, I think it was midnight or the 27th, but regardless, about 7 months ago, I instructed my webmaster to take all my websites down so that I wouldn't be falsely accused of holding myself out as being available to practice at a time when I'm not available. So I do find it a little bit suspect that she leaves out with a picture of a website that cannot be accessed.
If you, suspect, you have to govern yourself in a better way in this courtroom. There will be no attacks, no name calling.
I'm not attacking anybody, I
shouldn't have to
just think
say
that,
3 times.
okay, I think that when somebody puts a document out that purports on its face to be a fair and accurate depiction of what you would see if you went on the web yourself right now, that is at a minimum misleading. It's not the case. If you type in exclusiveduidefense.com, you're gonna see that you can't access the website. The only way to access and pull this picture up would be to go to the Wayback Machine.
Okay. Did you have any other housekeeping matters?
No, Your Honor, I just want to make it clear for the record, this is a printout from their Twitter accounts that were on the web today. We didn't make up a way back, and I know you understand that, and I would not do that. I want to make it clear, it's not a website, it's a Twitter. And I just wanted to make that aware for the court and also for the bailiff, because we did have, and I do have concerns, obviously, as well, based on that. But I'd like to move forward, and I think this goes to the point, and let's go to the merits. I know the court is busy, and I respect your time. First of all, this is not a derivative claim. This is 3 individual shareholders. And that's really important for both motions that they try to bring. And I want to also bring up, we've never been served. There's never even been service process. There was no summons issued.
And I did, in the order setting hearing, indicate that service was required. And if you have an objection to going forward today, even though you filed things, then we will continue it till next week.
And, Your Honor, I'd rather go forward. And we're fine with that. Our understanding is because, unfortunately, because Judge Sturman issued the hearing, and we do appreciate the hearing because it's also ex parte, and I know the court wants to hear it, and it was served on my clients, hence why we quickly also requested transfer to the business court. Then actually it was assigned to Judge Denton. They did a peremptory, we're here, which is fine. The issue was, then we had to rush to get oppositions, and if you note, I know you talked about earlier about treating this as a preliminary injunction. We only did it as an opposition to the TRO because we do plan to do motions and all of that. I know you also said service. There has not been service because there have not even been summons issued.
That's why when I got the courtesy copies yesterday, I was surprised.
And what we are going to do as well, Your Honor, with regards to the service, is we still will make those rights when we bring our proper motion to dismiss. But I want to go forward on the fact and why it's so important that there's only 3 plaintiffs here is because what they're asking for in relief on their injunction is in reality affecting every shareholder of this company. This is not a private company. This is a publicly traded company on the NASDAQ. And they don't have the standing to do that. And as this court is aware under the statutes and under NRCP 23.1, to do a derivative claim, you also have to do a demand, and there's certain procedures you have to follow. And that's automatic under Nevada law, as this court is aware. And as such, we are not able, in our view, they cannot get that relief that they try to seek. And as a matter of fact, as this court is aware, and I'm trying to just get me one document here, apologize. To determine whether a claim is direct or derivative, the court must examine who suffered the alleged harm, the corporation or the suing stockholders individually, who receives the benefit of any recovery or other remedy, the corporation or the stockholders individually, and that's Parametric Sound Corp versus 8th Judicial District 133 Nevada 417, and that's in 2017. And again, under the shown case, Again, NRCP 23.1 imposes a heightened pleading standard on a shareholder bringing such an action, and because the power to manage the corporation's affairs reside in the board of directors, a shareholder must, before filing suit, make the demand on the board, or if necessary, on the other shareholders, to obtain the action that the shareholders desire, and that's shown via SAC Holding Corp. 122 Nevada 621, and that's in 2006, and I know the court's aware of those. And that's because that's important, is we don't believe that they have the standing to bring the motion that they've brought for the temporary restraining order and or preliminary injunction. Importantly as well, they talk about harm. But they don't talk about is the balance of harm. And they don't give us any examples of how they'd be harmed. And I'm going to give an example. Today we hear, well, you know what, we're not trying to stop a meeting. We want to stop certain votes. But they don't tell you what those votes are. One of the votes in that 2 through 10 that they say can't go forward is to ratify the auditors. And again, what they also don't tell you is they're asking for relief they're not entitled to as shareholders. They're entitled to go to the annual meeting. They tried to get their own slate, these 3 individuals, of directors incorrectly through a lawyer that they says that doesn't represent them, who filed into this case. But what they don't say to this court is that they're not entitled to that because they didn't follow the proper procedures. This is a properly noticed annual meeting for a public company through proxy. So what they don't say is they couldn't do that. They also don't say is they have every right to show up to the meeting on the 27th. The problem is they know that the 3 of them don't have these type of votes, and I'm going to go further into that in a moment. So they're trying to come to this court to circumvent this because they know that they probably don't have the votes to undo the actions. But that's the risk of being an investor, a shareholder in a public company. You have a vote, but you don't get the remedy. And what they're coming to this court to do is get a remedy they're not entitled to as shareholders. They have no standing to do so. But they also don't talk about the harm. The harm is this company, and there's a long history of the company, and I'm familiar with it. I actually was involved in the company under Judge Williams' case. I was actually brought in by Ross Miller as corporate securities counsel in Nevada, because I worked for Mr. Miller when he was Secretary of State and I was Chief of Enforcement. And the reason that this is important, Your Honor, is that right now they're arguing harm, but they don't tell us what the harm is. But this is a $60 million cap company. This is a company that has, with the NASDAQ, a letter, and we attached the 8K. And what's important about that is, according to the requirements to remain listed and not be delisted, we must have a meeting by April 27th, 2023 to regain compliance with the shareholder meeting rule. And it's ironic, Your Honor, because I've come to court a lot of times when companies don't give me an annual meeting, asking for that meeting, as you know, under NRF 78. We're getting the opposite here. They want to stop a meeting. But this meeting has more implications than these 3 plaintiffs. It affects the company and the listing of the company. That also goes to the bond argument. And why is that? Well, they say they don't want any bond, and as you know, under NRCP 65, you have to have a bond if you get an injunction, and I would ask if you're not interrupting.
Your Honor, I'm going to interpose an objection, and this is not relevant because we've already gone past the bond.
All right, so,
Also, I thought you wanted an opening statement.
Please don't interrupt me. There will be no interruptions. I won't let her interrupt you. You don't get to interrupt her.
Thank you.
Overruled.
Thank you, Your Honor. And again, as we're talking about the bond under NRCP 65, which is, as you know, different. But what I want to address is they're saying no bond. We know it's required, but then they're saying a minimal bond. They're affecting a $60 million cap company, and if it gets delisted, Your Honor, minimally 10% of that is $6 million if they would want an injunction to stop an annual meeting, which will cause a company to get delisted. So, again, it's not a minimal bond. And again, the remedies they're asking for is actually against their own interests. So when we weigh the harm, and there's no harm that's been provided to us in any detail except conclusory statements, the harm here is not to the plaintiffs, the 3 plaintiffs. Again, we're not here on a derivative claim. It is to the company, to Vinco Ventures. And this also then goes into, Your Honor, their argument about a receiver. So first of all, I want to address, and now I hear, well, you know what, we'll let it go with regards to Ross Miller. But I want to address that because we did do an opposition. And the reason we did, Your Honor, is, well, first of all, if you look at both of their pleadings, under the TRO and preliminary injunction, they do cite to NRCP 65, but they don't cite to any other law. Under the receiver, they don't recite to any law. So when we did our opposition, we did it to NRS 32, but I also want to talk about NRS 78 in a moment as well. But with regards to Ross Miller, what they're in reality asking for, and by the way, he was not a receiver in Judge Williams, and I don't know if the court has seen, there was a stipulation and settlement agreement that was signed by Judge Williams where Mr. Miller was actually appointed the co-CEO. And if you read that, which they don't talk about, is it says, Miller shall be the sole CEO of the company. Miller and his team, which may include Gabe Hunterton as president, shall run the company subject to the oversight of the company's board of directors. And we've also heard he has a lawsuit against the company because there was an issue. He is no longer with the company, and now he's suing the company. His lawyer's in the courtroom today. What they're actually asking for is to have him appointed, even though he wasn't a special master or a receiver in Judge Williams' courtroom. They're asking without an affidavit, which is required for a receiver, they're asking that we appoint this gentleman, that it's a waivable conflict. But in reality, with an ongoing litigation, he could terminate the attorneys, and I'm not his attorney, or the company's attorney in that matter, because I do have conflicts. What would happen is, he could actually fire that counsel and settle the lawsuit with himself. That's what they're actually asking for. So now then, they try to come to this court and say, well, you know what, I'm going to back off of that too. So I just want a receiver. Or a special master, which they don't ask for in any of their papers. So I want to go through that a little bit. Again, to even get to a receivership, you have to show something. Now, under NRS 78.650, if they were over 10% shareholders, which they don't allege, they could try to seek a custodianship. Or you could even go under NRS 78.347, but that requires an affidavit and an insolvency or such a dispute with management. We don't have that here. Matter of fact, they first of all argue that the company, they don't argue it's insolvent, and I can make representations to the court as a public company that there is no question of insolvency of this company. That's not an issue here. I can tell you the company has sufficient funds, and hence why it's trying to get its listing to be able to continue. Because if it does get delisted, actually they could have a creation of a problem of insolvency, which is what I think that they're trying to create here from the remedy they asked for. But what we also have here is we have new management, Your Honor, and it was announced actually on a press release, public company, April 20th, 2023, where the board approved new executive leadership, which is naming Mr. Robertson as CEO and president, and Chris Polamani as CFO and COO. Now, the board has to be, as you know, under 78.347, the board has to disagree. We don't have a board disagreement. We don't have a derivatives request, and we don't have any disagreements. The disagreement is 3 shareholders that are coming to this court arguing, we don't like it. Now, to keep going, Your Honor, is, then they say, well, we can have a special master. Again, they don't say why they need one, but what they don't talk about again, and this goes again to NASDAQ. This is extremely important. The company has been in issues and negotiating with NASDAQ to remain listed. There were several issues with the company. And it is a requirement during this exception period with NASDAQ, as per the 8K, that the company has to, if there's any changes, not only have the meeting, but before July 7th, demonstrate compliance. And during this exception period that we're in currently, any change is called a significant event that occurs that affects compliance, which this clearly would do and a receiver would do. And then it includes any event that calls into question the company's ability to meet the terms would take away the exception period and delist this company. So again, we're faced with 3 individuals asking for a remedy that actually is against what they really want in the end. So it really, we don't understand why we're here, quite frankly. And so, again, Your Honor, I think, and we can go through, and I don't want to waste a lot of more time on that. They have this argument, and you'll hear it, I believe, that they believe that the company is bad, they don't like this Mr. Farnsworth, that he's a bad man, so you need to put a receiver. Your Honor, what they don't talk about, and it's a public document from the United States District Court, Southern District of Florida, is the conditions of release for Mr. Farnsworth in his criminal action that's pending in that district. Now, as we all know, that trial has not set to begin. Mr. Farnsworth was indicted in a criminal action on a securities action. But that action is not to be heard till, I believe now, March of 2024.
A charge is just a charge.
That's what I was going to say. Thank you, Your Honor. But I also want to read something to you, which is from the docket in that case, and I have a copy if the court would like. Okay. There's additional special conditions of the bond, and why this is important and relevant. Number 3, Mr. Farnsworth is prohibited from the sale, offering, or promotion of any securities, including debt, equity, or hybrid securities, without the permission of the government or pre-trial services, except for any securities of or relating to Zash Global Media, Vinco Ventures, Inc., or Icon Publishing, or any affiliates or subsidiaries of these entities, or any transactions relating to or involving Zash Global Media, Vinco Ventures, Inc., or Icon Publishing, or any affiliates or subsidiaries of these entities. The government looked at Vinco Ventures. This is why we're here today. They said there was nothing wrong with Mr. Farnsworth being involved. So their whole arguing, well, he's been indicted. Again, the government has investigated Vinco Ventures with regards to Mr. Farnsworth and does not have an issue because his condition of release on his bond was that he's allowed to be involved with this company. So again, there is no harm here that they can allege by allowing this meeting to go forward against them. The harm in reality, and again, we don't hear details, we keep hearing different things, but the harm again is to the company, and if the court is inclined to grant this bond, to grant this TRO, we need a bond, because again, the company would get delisted if we do not are allowed to go forward with the meeting, as has been noticed. And you can't just change the notice and say you can't vote on certain things without certain procedures. This was a proxy annual meeting for a public company with notice that's been properly noticed. There's been no allegations otherwise. And I ask the court if there's any other questions.
I don't, thank you.
Thank you.
All right, let's start fresh, Mr. Genis.
That's a lot to unpack. You want to talk first?
Yeah,
Go ahead.
if I may.
Of course.
So I'm a layman in this case, I'll admit it, okay? I live in Georgia. I'm a shareholder of 236,500 shares. Not just about a year and a half ago, our market cap was $3 billion. It's now 60 million. It's declined that much. I build websites for a living in software. And when I saw what was happening with this company, I reached out to Vinco Ventures many times through the appropriate channels. They have an email that you can reach out to. I've never received a response to them. So when I saw that there was no way to communicate with the board, I went to other online sources to see if anybody was engaging in the same problems. I found there's online investor communities. And so I started to find people who had the same concerns. Emails not getting answers, no response from the board. These are the people who are supposed to advocate for us as shareholders. That's their #1 responsibility. So I built a website. Next thing I know, I built this website in December. Next thing, it's called BBIGfamily.com. We now have 1,450 shareholders who put their name, email, phone number, and address on that website. And many of them have put the number of shares that they hold. And to date, we have almost 50 million shares represented on that website. Now, I know I don't represent them, but these shareholders collectively tried to find a way to stop what's about ready to happen. What is about ready to happen with this shareholders meeting would be that if these votes go through, and even though we know we have the votes to stop them, we know that the accountability over the stewardship of the shareholder meeting and vote is by a board who we believe doesn't have our best interests. So one of the things that would happen is diluting the shares even more. We've gone from, like I say, a high of 12 down to 25 cents right now. We are certainly worried about delisting from the NASDAQ. But my intent here today is not to hurt Vinco Ventures. I want Vinco Ventures to succeed. That's the only way I can get my money back. That's the only way all these other shareholders can get their money back, is if the company can actually succeed. So I was nominated by fellow shareholders, by these 1,400 basically. We get together on conference calls of 1,000 people, if you can imagine. Twitter has a function where you can do a conference call, it's called the space call, where hundreds and thousands of people meet regularly. And I was nominated when the pre-14 came out. We did retain a lawyer who was a shareholder. His name's Patrick. He works with Shoemaker out of North Carolina. We retained him. We didn't retain him for any of this. Let me finish.
What you retained him for? Not
We
this.
retained him to help us get through the nomination process, his firm. And we followed the procedures in the bylaws. Now, you need to know, we haven't had a shareholders meeting since 2021, since the fall of 2021. We have begged for a shareholders meeting. They haven't given us on-time filings. That's why we have been warned by NASDAQ of delistment, not just because of we're below $1, because they haven't filed their quarterly filings. And they still haven't even given us an annual filing, and they want to do a shareholders meeting without having an annual filing for the year 2022. So you can imagine, how could we possibly vote on anything without even them doing their job? They're required to give us a shareholders report for 2022. We don't even have fourth quarter or the last quarters of 2022. Excuse me, I'm a little nervous.
Relax.
But I just want to say, I submitted in my declaration, there's also 4 other shareholders who've submitted declarations. We've done hundreds of hours of work putting together this information, but not by ourselves. With these hundreds of other shareholders, we've crowdsourced this information to put it together. And here's the key. I agree with you 100%. Nobody is guilty until they get through their case. But there are some serious charges by the federal government on Mr. Farnsworth. And it's for doing things with securities with a previously publicly traded company that was driven to bankruptcy by the same tactics used here, by dilution of shareholder value. And I can't get into all the details of what happens with hedge funds and dark pools and all. That's not the case here. The case here is we are attempting to do anything we can. I would do anything, no offense, to have an attorney that's a securities attorney representing me. We rushed to find one. You wouldn't believe how many attorneys in Nevada have already had conflicts because they worked for Vinco. So we said we've got to do the best we can with what we've got. So we're going to go pro per. We started a fundraising campaign, and people have put together money. We're soon going to have enough money to retain the type of attorney that we would need to fight for ourselves and for our company. We're not trying to hurt anybody. Excuse me, if I may.
Of course.
I'm overly passionate. I don't know the board members personally of Vinco Ventures, but I do know that most of them have been personally appointed through Theodore Farnsworth. He's worked with them from Zash, a private company, and they show as independent directors. For example, Brian Hart and Judicial Court show as independent directors, but they actually worked for Zash Global Media with Theodore Farnsworth presently. There's also ties to Lisa King. She's previously worked with Theodore Farnsworth. Theodore Farnsworth himself was a co-CEO of Vinco Ventures, and now he's back out in the private world, and right now he's trying to ink a $100 million deal to buy the National Enquirer. He's put press all over the New York Times and other news outlets saying that it's done. We actually believe he's spent the money already. I don't know how he can make this happen because it requires a shareholder vote. And so that's one of the items on vote here. We're simply asking for this. If I could sum it up, we're simply asking to take our company back because we know we could do a better job. And we would nominate a new group of people, and if the shareholders collectively want to vote for the previous 5, then so be it. We would be gone. But if there's now new nominees on there and the shareholders vote for those new nominees, that would help. We would be able to turn things around. The nomination that we put through, we did follow the rules. The technicalities that they pulled through, now think about this. They haven't had a shareholders meeting. They've skipped it for almost 2 years. And they're not able to get out filings on time, but within just 2 days, they were able to put out almost an 18-page document saying why we didn't do things right with the nomination process. Things like this, very petty. You are required to have a personal address as your address as a nominee. It doesn't even say that in the bylaws, but they put that. And I didn't have the money or the capacity at the time to fight it. But I wanted to at the time. I wanted to fight every single one of those items that they put down that they said we did wrong, when they weren't even wrong. Things like, oh, you're not a shareholder of record, even though we have shareholders with our brokerage and street name. And so they got extremely petty trying to stop us from getting into there, because they know that what they're doing in the collusion with Theodore Farnsworth would stop. The pockets are getting lined with cash left and right. We raised in the past dilution almost $1 billion of our money. They diluted the stock to where we're at, almost 250 million shares. And we provided that money. We bought those shares. What happened to the $900+ million? It's just about gone, because they do joint ventures like AdRiser. Theodore Farnsworth says, hey, we're going to buy AdRiser. And he gets the board to approve because they've already worked for him before. And then he charges a transaction fee of $6.75 million. Guess where that transaction fee went? Into Zash, into his pocket. And guess what? He also gets equity in that new venture. So we buy AdRiser. We're the ones who pay for it. And then Zash gets 50% or whatever the equity was at the time. I can pull it up in the exhibits. And he's doing the same thing now. He wants to have 51% equity in the Inquirer. We don't even want to buy it. But he's willing to spend $100 million of our money. They say that we have a problem with our company in general, that our finances are bad. Then why are you going to come up with another $100 million? Are you really trying to build the company, or just spend shareholders' money and get another transaction fee into your pocket? I could go on and on about the different things, but my point here is this. I'm grateful that a fellow shareholder is willing to be a plaintiff with me, both Christopher and Darryl. Are there my first picks for plaintiffs? No, none of us want to be plaintiffs in a case. We just want to get our money back. And this is the only way we could find. We have to stop this meeting. If we don't stop this meeting, they're going to dilute it. It's going to go out of business, bankrupt. They know it. That's their modus operandi, is to take a business, put it out of business, so they don't have to deal with it. And then the hedge fund walks away with all the naked shorted stocks, shares, and we go away empty-handed. And we put together a significant amount of evidence. And what the defendants have said, there's some things with ruling and so forth, with statutes. I can't speak to every particular item, but I can say this: there's an emergency here. If we don't stop these votes and some of the items on the agenda, a lot of people are going to go empty-handed. And what they put on this bond, that, by the way, I should mention this, when the surety bond for Theodore Farnsworth was signed, guess who signed it? Our director of the board, Rod Vanderbilt. They have been together forever. Zash was created by Rod Vanderbilt. You can see the signature of who created the entity, the corporation. Those two corporations, Zash and Vinco, are one and the same. It's Rod and Ted, Theodore Farnsworth. And they've gone back and forth, putting people on both sides of the board, moving them back and forth between Zash and Vinco. It's all written. That's all legit. It's 100% verified evidence. And we can't do anything because they leave us out of the mix. We're the ones funding them. We're the ones making the company happen. And we have a declaration we put in today. Shareholders went up to our office. It's empty. Syracuse, where we're supposed to be able to attend for a shareholder meeting to verify shareholder records, there's nobody there. There's never been anyone there. They've gone to the Nevada locations. No one's there. We send FedEx there to serve. Nobody takes the mail. Only a few of the board members actually signed for the FedEx that we sent, because no one's at our offices. In our Singapore location, we have shareholders there. They've gone, and Lomotif is empty right now. This is our #1 asset. Lomotif is a competitor with TikTok that's about to be banned in the United States of America. And we're not able to have any access to our finances, to see who's working at our buildings, to talk to our board, and to get filings on a regular basis. So it is a publicly traded company, absolutely. But a publicly traded company has a responsibility to give the shareholders access to their finances timely, and to have a shareholder meeting every single year, and to allow us to vote on items before they spend our money. And I excuse my energy here. I've worked very hard. I've worked hard with my family. Excuse me.
Hey,
And all these shareholders have worked a long time to get to a point where we could actually communicate. That's all we wanted to do. And now they're putting out press releases left and right. And this last week, like 3 press releases have come out. Why didn't you tell us the roadmap we've been begging for 2 years? And with that, I'll just sit down because Chris looks like he wants to say something.
You know, I think Chris, Mr. Dennis, did you want to be the
I have a
one
few
to
things
speak
to
at the
address, but
end?
I can hold my thought and let Mr. Muntz speak.
All right, Ms. Muntz, let me hear from you. And just so that you know, when I look away, everything's voice activated. I'm actually looking at his face. All right, go ahead, please.
Your Honor, just real quick, and I
Hi, Your
apologize
Honor.
before he starts.
Shad, great. Okay, I can't hear myself. Okay. So I just wanted to address something real quick that I don't think has been discussed yet, and that is why the emergency with the shareholder vote next week, and why it's critical that we seek this TRO. The company has, we believe, illegally amended its articles of incorporation to convert 1 million common shares to preferred shares. We believe it's in violation of their reference statute, which is 78.380. And what they're wanting to do is use these preferred shares to have voting Series A preferred shares that can be issued to 5, which it's in their public filings in a financial agreement to allow 5 unnamed investors the ability to vote up to 50% of the total voting power of the corporation. So in other words, it doesn't matter if they're successful in proceeding with these Series A preferred shares. It doesn't matter what the will of the common shareholders are. They could effectively rig the vote in favor of their investors and in favor of their self-interested proposals. So that speaks to why we believe strongly that we need to seek this TRO, because it's not about harming the company, as Shad said. It's really about protecting retail investors, the investors that have been here for many years, that own, we believe, a majority of the company. As Shad said, the 1,400 plus shareholders that we talk to consistently on a regular basis. Your Honor, and Ms. Stein did say a lot of legal explanations and objecting to a lot of our motions forward, and understand that. But what she said is that she thinks that we don't have the votes, and that's why we're trying to stop the vote, which doesn't really make a lot of sense. Your Honor, they actually did try to have a shareholders meeting in 2022, and that shareholders meeting did not move forward. And the reason that shareholders meeting did not move forward, which is in public filings, is that they did not have the votes to approve their dilution votes at that point in time. So what they have done is they have rigged, or they have attempted, at least in my mind, allegedly attempted to rig the votes so that they could get the proposals approved this time that allows them to move forward with the actions and the transactions that common shareholders are not in favor of. Speaking to Dan, as Shad said, it's dilution. There's a vote on the table right now with Mr. Farnsworth where he would be able to secure 144 million shares of common stock, which is over 50% of the current total shares outstanding. He would be able to get that if that vote is approved. And in my mind, and in the mind of the investment community and any of the information and filings that we've seen to date, there is no consideration for that. There's no benefit to the company. There's no benefit to shareholders. It is merely them completing a transaction that benefits Mr. Farnsworth, because he has been able to control them since the inception since 2021, and then through adding these additional 2 board members, they have control. He can control the decisions that are made. And I understand the point that was made regarding he's just charged at this point in time that his charges don't bleed over. Well, Your Honor, we have very clear documented evidence that I have more of that I can provide later that show activities that are going on that are not in the best interest of that he is able to put his time on and complete. I just wanted to make that point. Again, Your Honor, in my mind, the real issue here are these Series A preferred shares. We believe they were, that they illegally amended their articles, and that they should not be able to move forward with these Series A preferred shares.
And you and I'd like to start by picking up on that point. It's my understanding.
And can you stand so I can see your face?
Yes, Your Honor.
Great.
Thank you. So it's my understanding with respect to the preferred shares issue that Mr. Muntz was just addressing, that in order to issue those, they have to have a shareholder vote that authorizes them to do so, and that's the missing link. There's never been a shareholder vote allowing them to do that, but they did it anyways. And so what our fear is, and the reason we're here with regard to that, is that their operational modus operandi is that they push through preferred shares that create super voting rights without shareholder approval, after not holding a shareholder meeting last year when they knew they didn't have the votes and they hadn't engineered this plan. So then they engineer that plan, and then when NASDAQ says, we're gonna delist you because you didn't have, for a number of reasons, one of which is you didn't have a shareholder meeting last year, and you're required as a public company to have a shareholder meeting every year. And now they want to hold the meeting, and we haven't had any communication for 2 years in spite of many, many people, and I'm talking thousands, probably tens of thousands of people contacting investor relations over and over again and getting no response whatsoever. And then what we believe they're going to do is they're going to exercise those illegally issued preferred shares to override the overwhelming majority of what I'm going to call the Main Street vote as opposed to the Wall Street vote. And they'll get all of the things that they want, which will result in the death of this company, which is what they want. I don't know if you remember Mel Brooks' movie, The Producers, but the theory of the movie, or the storyline of the movie was that these people created a play that was designed to fail so that they could rob the investors, and it didn't fail.
Springtime for Hitler.
Yes, Springtime for Hitler. And of course, in the plot, the play is a huge success, which is a problem for the con men because they can't pull their con if the play succeeds. And Vinco isn't quite there yet, but Vinco is kind of a stock market version of the Producers because Vinco has, in theory, a tremendous future and could be an extremely profitable company if it were operated by fiduciaries who have the company's best interest and not their own self-dealing interest in mind. And if they were operating the company and if they had been developing their major assets like Lemotif and Adriser, instead of acting like spoiled children in a toy store, buying toys and going home and not even playing with them and then going back to the store and buying more toys until they've used up all the money and can't afford to buy any toys anymore, and then the toys are obsolete and so everybody loses. What this company is doing is, and I understand more than probably anybody in this courtroom, as having been a criminal defense lawyer my entire career, which spans 45 years, that everybody is presumed innocent unless and until proven guilty, and that hasn't happened with Mr. Farnsworth yet. That's the operational work. Now, counsel made a point that I want to address when she said that she incorrectly suggested that that the federal government had looked into Vinco and Zash and 360 and Icon Publishing and everything, and that they had basically vetted it and approved him to do the work. I can tell you, having reviewed Pacer and having an intimate knowledge of how those processes work, that that's not what happened. What happened was, and when we talk about page 7 of the special conditions of, and there's really 3 conditions to Mr. Farnsworth's bond. There's the general conditions, there's the special conditions, and there are hidden conditions that only the parties can see. I'm not going to speak to why that is. I know why that is, but it's not relevant to these proceedings, so I'll move on from there. But when you look at page 7, and you look at it starts with a paragraph that talks about what Mr. Farnsworth cannot do. And it lists he can't transact securities and this and that and the other thing. And then at the end of that first group of thoughts, instead of a period, there's a comma. And then it says except, and then it goes into the exception and allows him to transact with Zash, with Vinco, with 360, etc. And what I know happened was that Ted's lawyer in that case asked for that exception in the bond, and the U.S. attorney agreed to it, and so the judge approved it. But the U.S. attorney, there's no evidence that the U.S. attorney actually vetted it before they approved it. They very well may have just taken Mr. Farnsworth's lawyer's word on why he said he wanted that. I can't really go beyond that at this point, but I can tell you that it is absolutely, there's no evidence, nor could there be at this point, to support counsel's allegation that the government vetted it and then approved it, because that's what I heard her say. And the only thing that we can say for certain is that the government approved it. We don't know if they vetted it. And in all likelihood, knowing how these things go, I can say with certainty that I'd be shocked to find that the judge himself vetted it, and I would be pretty surprised, just to say the least, to find that the United States Attorney or any of their deputy attorneys would have vetted it, but rather that there was a conversation dealing with the terms of the bond, which took place rather quickly when Mr. Farnsworth appeared on the citation to come into court to surrender and post bond and such. And the other thing that was alluded to but not actually articulated as thoroughly as it should be is that Theodore Farnsworth and Roderick Vanderbilt, who sits currently as the chairman of the board for Vinco, they're partners in business, but they're also partners in life. And when Mr. Farnsworth had to post a bond, and I'm not judging, that's not the point. The point is that you got Mr. Farnsworth, who at least is being, the government is being circumspect about his dealings in the stock market and his track record that anybody can see by investigating and looking at the internet for all of the companies that he's had is less than admirable in terms of securing positive performance over long term. On the contrary, his track record for every company is that it starts with a lot of money being raised and a lot of money going to him and then everybody else losing. And his modus operandi is to pay himself and nobody else. Now, I'm not going to get into the Jason Ma and Vincent Buddha lawsuit that's also before this court, but that has to do with vendors not being paid. So while Mr. Farnsworth is going to get his transaction fee, his finder's fee for each of these items, which he always has, and then he's going to retain ownership, and you've heard about that. That's what they're trying to do next. In other words, they got money for Lemotif, and they blew through it. They got money for AdRiser, and they've blown through it. And now they want to acquire the Inquirer and get money for it and then blow through it. And ultimately, what you have is a situation where a company that could be a huge success, but for the fact that the board members are not staying true to their fiduciary duty and they're engaging in self-dealing. So for instance, one of the ways that money has gone out is they created a company called, how do you pronounce it?
Magnify You.
Magnify You, and which is a private company, and it's all the bills for Magnify You are paid by Vinco. But Vinco doesn't get, but what's percent?
I believe it's 15%.
15% of the profits. So Vinco pays all the expenses, but only gets 15% of the profits. And who works for Magnify You? All of Lisa King's family. So
Lisa King's the founder.
And she's the founder. So Vinco loans a bunch of money to Lisa, and then they start this company, which is not publicly traded, and Lisa employs all of her family, and Vinco pays all of the expenses and takes very little of the profit. And that money that's being paid to operate Magnify You and to pay the family and to give them the leased cars and the increased benefit, and the benefits are pretty significant. There's a lot of money going out. That's shareholder money, and that's how this whole thing is. You get the money from the shareholders by diluting the stock and then distribute the money to Ted and his friends, and then to find another project to raise some more money and ask for more dilution and then distribute to their friends and keep doing rinse and repeat, fill the piggy bank, empty the piggy bank until you can't fill it again, and then take the empty piggy bank and file bankruptcy. That's his MO. It's a very clever scheme. I like Mr. Vick, I didn't want to be here. I didn't want to be a plaintiff. I certainly don't want to be in court arguing about this. We tried very hard to find a lawyer. I have a fool for a client. There's no mistake about that. I'm a fish out of water here. My experience in court is vast. My experience in corporate is zero. My experience in civil is very small. And so if you want to have a competition about Nevada statutes between me and any other counsel, I'm going to lose that. If you want to have a competition about what is required to dot the i's and cross the t's in corporate law. I'm gonna lose that. But what I do know is that as a metaphor, my investment is on a bus that is headed off a cliff, and everybody on this bus, family men like Mr. Vick, people like Muntz, have put a lot of money into this company in good faith, believing that the company would succeed and that their investment would prosper as a result of that. And after 2 years of watching the stock price go down, 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 for me, 98%. 98%, I can't afford to lose that. I'm hoping to make that money back so that I can use it to pay taxes that I owe. I can't afford to lose it, and I'm about to lose it. And we couldn't find a lawyer in time to take the wheel to avoid this corporate bus from driving off a cliff with our money and everything being lost. So out of desperation and for no other reason, I told Mr. Vick, I said, I don't want to be on this case. I've had enough. And I said, and frankly, I have baggage. It's no secret. Counsel has made a point of it, and I don't need to repeat it, but I said that baggage is not something that you guys should be saddled with. But if nobody's going to take the wheel, and this corporation is going to drive off the cliff with our investment, and our last few pennies are going to be lost, instead of having at least a prayer of saving that company, and it's savable. I know, for instance, with Lemotiv, if Lemotiv was developed properly, it could fill the void for TikTok, if TikTok or when TikTok gets taken off. I know that Mr. Vick could build the Lemotiv platform, and I'm not saying he should, but I'm saying just he could build that Lemotiv platform to the point where it would be as good or better than TikTok, and it would take him no more than 6 to 8 weeks, probably less. So it's not like we couldn't get up to speed. It's not like we couldn't bring the stock price up above $1. It's not like we couldn't do all of these things and save this company. But the people that are driving this company right now don't want to do that. And so we're like the only people that were able to get this in front of a judge, as we are today, as a Hail Mary, if you will, and say, give us a moment. Now, counsel talks about what is the harm, okay? While she was talking about that, I had an idea as to a response for that. The harm for the company is that it would be delisted. And if we were to take counsel at her word that her clients don't want that to happen, and let's assume that that's true arguendo. I don't believe that to be true for a minute, not even for a second, not even for a New York second. However, let's assume that it is true. Could they do it? Yes, they could. They're not doing anything that they should be doing in order to accomplish that. One simple step would solve that problem. If they really were honest about wanting to save this company, they could voluntarily ask NASDAQ to halt trading of the stock in lieu of being delisted. They could hold their shareholder meeting, which is one of the things that they're in deficit of. And because they would be in halt, then the rule having to do with being below $1 and all of that would be suspended. It would be abated for the moment. And we could begin to see some action that would be consistent with the lip service that they're actually trying to do something. As Mr. Vick has said, we don't have current financials. Now, I'm going to ask you a question. If you were, let me ask it a different way. I don't want to make it personal. If a person were an owner of a company that's publicly traded and they were being asked to make a decision about a significantly sized investment, and that decision was financially based, in other words, you're being asked to do something to raise money or to cut costs or something, do you think that it would be important for that person, in order to intelligently exercise their vote, that they would have proper, up-to-date, and accurate financial statements so that they could utilize that information in order to make an intelligent decision about whether to vote yay or nay on each individual item? I happen to think that anybody who would be asked that question would say, I would really like to have that information before I exercise my vote. In fact, let me take it a step further and say that I could not intelligently exercise my vote without that information. And that's the position that we're in as shareholders, is they're asking us to make some very important decisions about huge financial transactions, such as buying the National Enquirer, and we don't even have the financials to know whether or not they could even complete the deal. What we do know is they have enough money to pay Ted's finder's fee. What we do know is that if they were put into Chapter 11 receivership right now, and I'm not saying that's the solution, I'm not saying that's what we're asking for, I want the company to succeed. But if they went into Chapter 11 right now, there's enough cash in the company to make the common stock shareholders whole, and my understanding, could be wrong, my understanding is that we would be preferred creditors. And so, I see again, counsel shaking her head no, and whether she realizes it or not, that does break my train of thought. So I would ask that I won't do that, and if the court would please, consider asking counsel not to do that.
Let anybody act out. I know what the law is on this stuff, guys.
Okay, so in any event, what I'm saying is this. We don't want the company to fail. We don't want to do anything to hurt the company, but we don't want the company to hurt us. And as between us and them, the empirical evidence is overwhelming that they have gone out of their way to treat us as though we don't count. They don't want to talk to us, they don't want to know about us, and they don't want to release any information. And I suppose you could say it's pure speculation, but there's been no press releases about anything until this lawsuit was filed. And then all of a sudden, it's one press release after another about all the wonderful things that they're doing. You know what the telling thing is, though? With all of these press releases, normally in the stock market, when a company issues a press release about something wonderful that they're doing, you can see evidence of it in the stock chart. You can see the stock price going up. You know what you see when you look at the stock chart for Vinco over the last few days? The stock, three things actually. The first thing that you see is that the stock price hasn't gone up. The second thing that you see is that the volume of stock that's trading is relatively nothing. Like, when this stock was trading heavily, when it was at its all-time high, and the price hit, I think, $12.49, it's about 2 years ago. 300 million shares a day. Today, the last time I checked, we had traded under 3 million shares. The third thing that you'll see if you know how to read TA on a stock chart is there's a thing called on-balance volume. Now, normally when a stock price is depressed and it's going down, the on-balance volume looks a certain way. When you look at the on-balance volume of the stock chart for Vinco Ventures for the last year and a half or two, the on-balance volume tells a completely different story than the stock price. Completely different. If we were to go on the on-balance volume, we would be at an all-time high right now. Now, again, we're not here to talk about dark pool trading. We're not here to talk about conflict of interest for market maker. We're not here to talk about any of that. But there are reasons why this stock is going from very valuable to worthless. And it hit critical mass where we're almost at worthless. And that's why we're here. We've tried everything that we could think of as intelligent investors to try to become engaged with the company in order to find a path forward that would be good for them and good for us. And all we've gotten is being treated like the unwanted red-headed freckled stepchild at the family picnic. That's it. And so when we got to that point, and when Mr. Vick and 3 or 4 other shareholders tried to put shareholders onto the ballot so that the stockholders would have an option and decide who might they like to be on the board, the company that couldn't get anything filed on time, that couldn't hold meetings on time, that couldn't do anything on time, that when they did file with the SEC on their 10Qs and their 8Ks and all of that they cut and paste and they had the wrong names on them. This company can't seem to do anything right, but when they don't want us to get ahead in a way or get in their way, they can crank out a 10-page letter pointing out all of our deficiencies. It wasn't mine, I wasn't part of that, but could point out all those deficiencies very quickly. And then when a court case is filed and they're faced with an impending TRO that rains on their parade, they can bang out press release after press release after press release. And one of the press release lines was this thing about the acquisition of the Inquirer, which requires a shareholder vote, and it's one of the items that's on that list. I forget which number it is, but it's between 2 and 10. And they're asking us to approve that, that purchase. But if you look at the news releases, starting with the article that came out in New York about 2 weeks ago, Ted Farnsworth is in press saying, we've already closed this deal, I'm already operating this company, and we're doing this and we're not doing that, and we're not going to cover the Trump trial and so on and so forth. He's talking about it like the deal is done. And from what we can tell, that may actually be the case. The money may actually, the checks may actually have been written in cash, but the shareholders haven't voted on it yet. Now, why would they do that if they didn't think that they had the vote? And how could they have the vote when the Main Street investors, of which Mr. Vick and myself and Mr. Muntz are the current face of in this courtroom, although we don't represent other people, it's not a class action lawsuit, the face of the Main Street investors owns, and again, talking about the Big Family website, the Main Street investors own somewhere about 81 to 85% common shares of this company. We're the major shareholders of this company collectively. Earlier when Ms. Stein was talking, she mentioned something that had to do with if you did it right and you had a certain percentage, it was 10 or 15%. And we have way more than that, but we don't have enough to override the preferred shares 51% supermajority vote, which should have never happened because we've never approved it. And we're coming up on a meeting in a couple of days where they're going to exercise those shares, even though they were illegally issued. And once those eggs are scrambled, we'll never be able to unscramble them, because here's what's going to happen. They're going to have the meeting, they're going to hold the vote, they're going to pass the resolutions that they couldn't pass last year when they had the meeting and canceled it because they knew that they didn't have the vote and they didn't have some sort of workaround mechanism to create the vote out of whole cloth. And so now that they've created that, they want to rush forward, and we're in a position where if they get that, we get a reverse split. The stock price comes up above $1, and then they push that deal through, and they get the 360 deal, and Ted gets paid yet again, and then we watch the stock price go down, 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 and we get back to this point, and then mark my words, you're going to look at this company, if you don't grant this injunction, at least in some incantation, in some form, then you're going to look at this stock one day, a year or two from now, and you're going to think, hey, I wonder whatever happened to BBIG, that case that I had in my courtroom, and you're going to open it up and you're going to go, oh, they got delisted. They went bankrupt. And I'm not going to speak to what else you're going to see in other courts outside of the Nevada court and outside of civil courts, but you're going to be thinking about what you heard here in this courtroom today 2 years from now, and you're going to look at it and you're going to go, wow, Mr. Vick was right, Mr. Muntz was right, Mr. Genis was right. And the only thought I have to ask to you is, if there's a legal mechanism whereby you can find the way to protect the company, which we want, I don't know how many more times I can say this or how I can say it better, we don't want to harm the company. Our money is in that company. If that company's harmed, our investment is harmed. We want this company to succeed. What we don't want is we don't want insiders that are engaged in insider, no, what's the thing I looked up today, the dealing?
I'm sorry.
I'm going to say insider dealing for lack of better description, where they're trading our money back and forth between these different companies, and they're violating their fiduciary duty. We want that to stop. We want people that actually know how to run a company successfully and can be fiscally responsible with expenditures and purchases and product development, and that if they, let me just say it this way. I had no idea that these offices were empty buildings. If I had the ability to travel to the locations where this company supposedly is doing business and all of their subsidiaries are doing business, and I went to the front door and saw that the door was locked and the office was empty, would I invest in that company? Would anybody in this courtroom invest in a company if you went to the corporate headquarters and found that it was not operational? I don't think so. And I didn't know that when I bought stock in this company. I wish I did, because I wouldn't be here. So now I know, and it's a day late for me in my investment, but it's not too late. It's not dead yet, and it doesn't have to die. And the way that you can keep it from dying, and the only way that you can give Vinco Ventures and BBIG a chance to be the successful company that we believe that it can be, would be to take the approach that Judge Williams took, which was, he said, I want to protect the shareholders. We don't need to get into all of the details of that case, but the bottom line driving force of Judge Williams, as I read it from afar, was that he did everything that he did because he thought that he was taking action to protect the shareholders. That's all we're asking. Take some action to protect the shareholders. I'm sorry that I'm not more well-versed in corporate law. I'm sorry that I'm not more well-versed in Nevada procedure. The procedures from court to court differ. Counsel's talked about service and such. And before, when we first got started, we were serving with a statement saying proof of service. And then afterwards, we saw that the clerk's office would serve everybody just by virtue of us getting filed. Ms. Stein sent me an email, and without getting into all of the minutia of it, the most important part was she asked me two things. Please stop serving my client, and I understand that, now that we know that they have a lawyer. And the second thing that she wanted to say was, I want to get proper service. I'm sorry if I misunderstood, but for instance, in federal court and in other courts that I've practiced in, not this court, when you file a document and the clerk then sends copies of the documents out to everybody that is on the roster, including counsel for both sides, that counts as service in some courts. From what I've heard in this courtroom, it doesn't count as service. So I've been educated, and again, this falls under the concept of the fact that when I'm representing myself, I have a full fair client. I'm completely out of my my home turf. This isn't a criminal case. This isn't a case of constitutional dimension. If it was, I would feel at home. This isn't a California courtroom where I made most of my adult living practicing law. This is a jurisdiction I've never taken the bar in. I've never sought to be admitted to. I've never applied for Pro Hoc VC admission. My only connection with Nevada is I've attended legal seminars here for the NACL and for other things, and I do have a couple of criminal lawyer friends that practice here. You probably know at least Mace Yumplowski. Mace is a very close friend of mine. It's a small world, and Nevada's a very small legal community. I also, unfortunately, know lawyers that have been disgraced in this town. I'm not personally friends with them, and I'm not going to mention names. But bottom line is, nothing would make me happier than to see this company succeed. I know that Mr. Muntz shares that. I know that Mr. Vick shares that. I know that the 1,400 people that signed up for the website that Mr. Vick created share that. The last week when we were here filing papers and everything, I came and Mr. Vick came and we worked from a hotel room and got papers filed. We met another investor here. His first name is Jared. This investor and his father invested $4 million into this company. And their $4 million investment is almost completely eviscerated. And they're devastated by it. And this young man that I met, who convinced his father to invest over $4 million, is devastated by the fact that he led his father to a ruinous financial investment. When I met this young man, he was practically in tears over saying, how do I live with myself when I got my father to invest in this company that I really believe was going to be a very, very beneficial investment. And now, when I sit down with my father, I feel ashamed. I feel unworthy. And the damage that the board of directors is causing to ordinary men and women and family people and even children. I know one investor who, he keeps telling his young son about how this investment is gonna be so good for their family. And the young son keeps asking his dad, hey, how's our investment doing, Dad? As an 8-year-old boy asking, how's our investment doing? Because he can't have the birthday toys that he wants because the family put the money into Vinco. And the money's not there. Meanwhile, we see pictures of Ted flying around Las Vegas in a helicopter at EDC last year. How did he get the helicopter? With our investors' money. These people that are running Vinco see the investors' money as their personal expense account, and they're spending it like drunken sailors. We need your help. It's that simple.
Thank you. So the way it usually works is that the moving party talks, and then the opposition, then we have a reply. You had a lot of time, but Ms. Stein did ask for a chance to say something more earlier, because the plaintiffs are the moving party. I'll let you have the last word. Ms. Stein?
Thank you, Your Honor. First and foremost, they're mentioning a declaration that's why I was gonna ask, we never got. Turns out something was filed at 141 and not served on us again.
What it was pictures of Vinco showing that non-operations.
Well, first of all, they're obviously not evidentiary, and that's one of my issues with everything we've heard. But what they don't understand is we actually closed the offices because of all the threats, because of these lawsuits. But I want to go back to what's really more important here. They keep talking about, we heard Mr. Vick talk about, he created his own website, that's his job. What they don't talk about is, and we heard now, they have 1,400 investors they're supposedly representing. Again, they do not. This is a 3 plaintiff case that we're dealing with here. And what's important here is they keep talking about these investors, they don't have money. What they don't tell you is that part of this website was to raise money to hire a lawyer. They raised $28,000. We also believe that's where the bond got paid from. And that's paid for them to be here in Las Vegas, that they've been here camping out in front of the court and going to the court. That's what they keep posting about. That's public, Your Honor. So what they don't tell you about is, what we're really here for is, they're trying to do a shareholder derivative suit. But we also hear, and I don't want to spend a lot of time, but they keep throwing all these allegations. What I think I'm hearing is now they're arguing business judgment rule. They don't like the way the board is operating. It's not a business judgment rule case either, not brought correctly. The bottom line is everything they're arguing for can be handled, and I apologize, at an annual meeting. They have the right to vote. What they don't tell you, and they give a lot of false statements, excuse me, Your Honor.
Do you need a minute?
No. Thank you. We've heard a lot of allegations thrown out without any evidence, but I'm going to go back to the beginning, what they're not talking about. This company had a hostile takeover. There was, as a result of that, there was a lawsuit. There was a prior CEO, Mr. Colucci, which was part of the lawsuit with Judge Williams. They don't talk about is because during that time you cannot talk to investors. There's rules. The securities laws are completely different, federal securities laws versus state corporate law, but there's rules on when you have to do that and the ability to talk to shareholders. They don't talk about, they keep, I think we've heard, apparently Mr. Farnsworth is public enemy #1. The problem that they don't have is they've made so many baseless allegations without any evidence. For example, Mr. Law, he never has worked for Zash, but we heard them say that today. And again, they're arguing about independence. They don't talk about Richard Levishin, and I apologize if I mispronounce his name, he'll probably kill me later, is independent. They don't talk about that the directors are independent. They don't talk about the National Enquirer deal because I don't think they understand it. It's not a done deal, but it's also an income earning deal. But then we hear, and what's very concerning to me, they're like, well, the board doesn't respond to me. When you invest in a public company and you're not a major investor, you're, as you know, even a private company, if you don't own a certain amount of shares and you're not a majority.
Well, yeah, there's a public relations person though.
Exactly, but when you're in a dark period where you're not allowed to speak to them, you have to abide by that. On top of which, though, we hear about bankruptcy. Well, and I know you know better than most about bankruptcy law, probably better than I do. But Chapter 11 would automatically be delisted, and shareholders are not creditors. They become underneath the creditors. So again, I kind of surprising what I'm hearing about, and I understand the emotion, but I don't think they understand what's going on with this company. And maybe if they went to the annual meeting to understand that, they could get those certain things, but they all get to vote at the meeting. They all, and by the way, there's 68,000 shareholders, not 1,400 that they supposedly are representing, even though they said they're not. And then they talk about that they can't get records. There's procedures, as you know, under NRS to request corporate records. Those have not been followed. They continue to not follow procedure. Instead, what we're faced with is a bunch of 3 rogue plaintiffs who are shareholders, one of which clearly has created his own website, and we don't know why, but it's been creating a thing, getting paid, quite frankly. And what they're doing without evidence is coming to this court saying, you know, give us this because we're not going to get that when they go to the meeting. That's the real issue. And the other thing is, where the statute here, as you know, provides for appointment of receiver, the statutory requirements have to be met or the appointment is void and in excess of the jurisdiction of this court. Well, I get that they're not attorneys or licensed Nevada attorney. The problem we have here is, Your Honor, that in the end, you still have to follow our laws. They've come to this court asking for remedies they're not entitled to in the position as the 3 shareholders. They haven't followed the proper procedures. They haven't properly pled, and again, we would just ask that this court deny their motion for a temporary restraining order and also deny their motion for a receiver.
All right, so I think we need a break. I know that I need a 5-minute break. So I'm gonna ask the plaintiffs if you can, you'll have 15 minutes to use however you want, and I'll ask you to confer about that during the break. It's 3:43. Well, let's be back at 4, please. You guys can stay, please. And I can't invite anybody to use the restrooms in the back. They haven't opened it up yet for us.